morning, good afternoon, good evening, depending on the time that you are watching this video. This is Group 1 Criminal Law presentation on murder as a type of homicide. Sit back, relax, and enjoy. Homicide is the killing of one human being by another. It is a general term and may refer to either a non-criminal act or the criminal act of murder. Some homicides are considered justifiable, for example, execution by the order of court, while others are said to be excusable, e.g., self-defense. Criminal homicide is not regarded by the applicable criminal code as justifiable or excusable. Types of homicide: murder, manslaughter, vehicular homicide, and negligent homicide. According to Section 315 of the Criminal Code, any person who unlawfully kills another is guilty of an offense which is called murder or manslaughter according to the circumstances of this case. In this presentation, we'll be focusing on murder.
Section 306 of the Criminal Code defines murder as the unlawful killing of another person in any of the following circumstances. 1. If the person intends to kill that particular person or another person. 2. If the person intends to grievously harm that particular person or another person. 3. If death is caused by means of an act done in the prosecution of an unlawful purpose, which act is such of a nature as to likely endanger human life. 4. If the offender intends to do grievous harm to some person for the purpose of facilitating the commission of an offense, which is such that under offense the person can be arrested without a warrant, or for the purpose of facilitating the flight of an offender who has committed or attempted to commit any such offense. 5. If death is caused by administering anything for either of the purposes I have said before. 6. If death is caused by willfully stopping the breath of another person for either of such purposes, the person is guilty of murder.
To prove the offense of murder, the prosecution must establish 3 elements. 1. That the deceased is dead. 2. That the acts of the accused caused the death of the deceased. And 3. That the accused acted intentionally, knowing that death or grievous bodily harm will be the outcome of his action. Now to the first element, that the deceased is dead. In establishing these elements in court, a major question that often arises is whether it is necessary to produce the corpus delicti, that is the corpse of the deceased, as an evidence that the deceased is dead. However, the court in Onabanjo versus the state established that it is not necessary to produce the corpus delicti as an evidence that the deceased is dead. In Onabanjo versus the state, the dead body of the deceased was not found. Instead, what was found was items belonging to him and human parts, such as strands of hair and teeth. Part BGSA. Accordingly, where there is an evidence that a human being has killed another human being, the latter will be convicted for the death of the former, provided that the prosecution is able to establish a nexus between the act of the accused and the death of the deceased, leading the court to a conclusion that the accused has killed the deceased.
The second element that can be used to prove the offense of murder is that the act of the accused caused the death of the deceased. That means a link must necessarily be established between the act of the accused and the death of the deceased. In the case of Patrick of Folete versus the state, the accused hit the deceased on the head with a kitchen stool. The court held that since there were two contradictory medical reports and the prosecution could not prove beyond reasonable doubt that there was a causal link between the act of the accused and the death of the deceased, then he could not be convicted for murder. Additionally, in the case of Apugo versus the state, the court held that since the prosecution could not prove that the blow thrown by the accused caused the death of the deceased, the accused cannot be said to have killed the deceased. This is to show that in order to prove the offense of murder, there must be causal link between the act of the accused and the death of the deceased.
Another element that must be proved in a murder case is intention. The prosecution has to prove that the accused person had the intention of causing grievous bodily harm to the deceased or kill the deceased person, as seen in the case of Olabisi versus the Nigerian Navy, whereby the accused shot the deceased in the mouth. This act of the accused shows that the accused person intended to cause grievous bodily harm to the deceased, or is aware, and it's also that is aware of the fact that death may be a consequence of his action.
Having established the 3 essential elements when it comes to proving the offense of murder, it is important to establish that proving murder must be beyond reasonable doubt. That is established by virtue of Section 135 of the Evidence Act. However, the prosecution in doing this usually rely on these means. First, the conventional statement of the accused person, the direct evidence of the ear witness, as well as the circumstantial evidence. When it comes to the conventional statement of the accused person, this was actually the confession that the accused person made during the period of interrogation. When it comes to direct evidence or ear witness, it means that maybe an individual saw him or her while he or she was perpetrating the acts in question. And when it comes to the circumstantial evidence, the circumstances surrounding the case also matters when it comes to proving the offense of murder. The case of Julius Aburiba versus the state was a good case law to this effect. In that case, Julius Aburiba confessed to killing of the deceased alongside with some set of people. Equally, there was a medical evidence that corroborates his conversion, and by the virtue of that, the court convicted him of murder of the deceased. And the court went ahead to establish that it is not necessary that the prosecution to raise all these three means that there was direct evidence, there was conventional statement, as well as circumstantial evidence. One of them suffices. So far, the prosecution was able to establish one of them. The accused person will be convicted of the offense of murder. And by implication, it means that either direct evidence, conventional statement of the accused person, or the ear witness actually matters when it comes to proving the offense of murder.
The last seen principle is a principle of proving the offense of murder, in which the law presumes that the person last seen with the deceased is responsible for the deceased's death, and the person last seen with the deceased has the duty of providing an explanation on what happened to the deceased. In the case of Pius Nweke against the state, where the accused was last seen with his wife in the farm, the court held that since he had not provided an explanation on what happened to the deceased, he was therefore responsible for her death. Also, in the case of Moses Joa against the state, where a policeman escorted the accused and the policeman was not seen again, and the accused did not provide an explanation on what happened to the deceased, the court held that the accused was responsible for the death of the deceased.
Section 310 provides for causing the death of someone by threat. It provides that a person who by threat, intimidation, or deceit causes another person to do an act or omission which causes the death of that other person, it would be deemed that he has caused the death of the person. Simply put, if person A threatens person B to jump into a river unless he would be killed, and person B goes on to jump into the river and dies as a result of jumping into the river, in the eyes of the law, it would be deemed that person A had killed person B, even though he was not the one that physically pushed person B into the river. So section 311 of the Criminal Code provides that a person is deemed to have killed another person if he does an act or make an omission that hastens the death of the person, even if the person is suffering from a serious illness before. So simply put, if person A is suffering from a terminal illness and person B does an assault to person A, which results into the death of person B, despite the fact that person A was already suffering from an illness, it would be deemed that person A has caused the death of person B.
Section 312 of the Criminal Code provides that when injury or death might be prevented by proper precaution, that it is immaterial that the injury might have been avoided by proper precaution on the part of the person injured, or that his death from that injury might have been prevented by proper care or treatment. While section 313 of the Criminal Code is to the effect that when a person does grievous harm to another person and such person has recourse to surgical or medical treatment and death results either from the injury or the treatment, he is deemed to have killed the person, and it is immaterial whether the immediate cause of death was the surgical or medical treatment, provided that the treatment was reasonably done under proper care and with good faith. Section 314 of the Criminal Code provides the limitation as to the time of death, that a person is not deemed to have killed another if the death of that person does not take place within a year and a day of the cause of death.
Under the section 319, subsection 1 of the Criminal Code Act, the punishment for murder is death. This position has been affirmed in several cases, such as Pius Nweke versus the state and Moses Joa versus the state, where the court affirmed the conviction for murder and imposed the statutory sentence of death.